importantly. I'd like to start this meeting importantly, though, by acknowledging the Gadigal people of the Eora Nation, the traditional owners of the beautiful land that I'm working on today. I recognise their connection to land, waters and culture and pay my respects to their elders past, present and emerging. E1's very fortunate that for many, many years we've had an Aboriginal outreach and engagement program, and as a result of that, I've been welcomed onto many Aboriginal lands right across New South Wales. They are unceded lands. Aboriginal lands always will be, always was, and of course, when we go there, they are welcoming and so friendly. I've learned so much from communities and individuals. It's been a real privilege, and I know I just have so much more to learn. And today is part of that extra learning. So today's webinar, I think, is very special as it's going to shine a light on the importance of recognising Australia's First Nations and on taking up their invitation to walk with Aboriginal and Torres Strait Island peoples in a movement to create a better Australia for us all. Associate Professor Sean Brennan is Director of the Indigenous Legal Issues Project at the Gilbin and Tobin Centre of Public Law and was the Director of the Centre itself from 2014 to 2018. Sean teaches and writes mainly in the areas of constitutional law, native title and Aboriginal land rights. In 2016-2017, Sean was part of the pro bono legal team that supported the regional dialogues and First Nations Constitutional Convention, which culminated in the Uluru Statement from the Heart. Today, he's so generously sharing his unique insights with us about the background to these dialogues, the convention, and perhaps most importantly, help us understand the real focus of the Uluru Statement from the Heart and how we can, if we choose to take it forward. Sean will speak for around 20 to 30 minutes and then we'll have a facilitated Q&A. Please put your questions in the chat during his presentation so that we can get onto them as soon as it's time to do that. So welcome, Sean.
Thanks so much, Janine. Hello, everyone. I acknowledge the Bidjigal people and the Gadigal people, the traditional owners of the Sydney campuses of University of New South Wales, from where I'm coming to you today. And I also acknowledge the Aboriginal and Torres Strait Islander people who are joining this webinar from around Australia and everyone. Thank you to everyone for attending it and participating in it. And I want to thank Janine and ANZOA for the opportunity to talk today about the important choice that Australian voters will be facing in the next 3 to 5 months when we go to the ballot box in particular and cast our vote, yes or no, to the question whether we support constitutional recognition through an Aboriginal and Torres Strait Islander voice. In opening today's session, I wanted to focus on 2 things in particular: how we got here and what we'll be voting on. In other words, first, the process that's brought us to holding a referendum in late 2023, and then go through 5 basic features of the proposed amendment that has passed Parliament and would be the words that become a new Section 129 in the Australian Constitution. So turning to the process that brought us here first. The proposal that will go to Australian voters at a referendum, we expect will be held in October or November this year, is the product of a long and careful process of deliberation and scrutiny. So proposed Section 129, which I'll show you later on in the presentation, is the fulfilment of a 16-year national discussion of constitutional recognition. And at the centre of that discussion, as Janine's foreshadowed, is the Uluru Statement from the Heart, delivered to the Australian people on the 26th of May 2017, the 50th anniversary of the 1967 referendum. The call for a voice in that statement also has deep roots in generations of advocacy from First Nations people who've long sought to do something structural and meaningful about Indigenous disempowerment, and to do something about a constitution that makes no reference to them or their societies that have occupied Australia for up to 65,000 years, perhaps more. So in 2007, Prime Minister John Howard initiated the contemporary discussion about recognising Aboriginal and Torres Strait Islander peoples in the Constitution. As some people might recall, having earlier ventured some controversial words in an unsuccessful proposal for a preamble put to the people in 1999, on the same day as the Republic referendum. In fact, since 2007, all 7 Australian Prime Ministers, Howard, Rudd, Gillard, Abbott, Turnbull, Morrison and Albanese, have gone to elections saying they're committed to recognising Aboriginal people and Torres Strait Islanders in the Constitution. As you can see here in this slide, in 2010, crossbenchers agreed to support the minority Gillard government on conditions that included advancing the issue of constitutional recognition. So the government formed an expert panel of non-Indigenous and Indigenous people which conducted consultations around Australia and recommended a package of proposals. That included putting a prohibition on racial discrimination in the Constitution. The opposition leader at the time, Tony Abbott, expressed reservations on the day the expert panel report was delivered, and the Gillard government never formally responded to the report. The debate over constitutional recognition then went into a prolonged period of drift, postponement, and referral to a series of working groups and parliamentary committees. The governments of the day, from both sides, were unwilling to invest real political capital in resolving the question of what proposal should be put to the Australian people. Eventually, as you see here, 40 Aboriginal and Torres Strait Islander people met with Prime Minister Tony Abbott and Leader of the Opposition Bill Shorten at Kirribilli House in an attempt to address this loss of momentum. They communicated a message that many Indigenous people felt the debate was largely being carried on with non-Indigenous voices to the fore, and that it exaggerated the significance of symbolic words over changes to the Constitution that would have a substantive legal effect. It wasn't speaking to the crisis of disempowerment that was inflicting their communities and perpetuating wide gaps between the Indigenous and non-Indigenous population in health, education, housing, employment, and on other fronts. This Kirribilli statement from the meeting held in July 2015 was really the decisive turning point because it injected energy back into the movement towards meaningful constitutional recognition. Lisa, could we have the next slide? So soon after, new Prime Minister Malcolm Turnbull established the Referendum Council to advise the Prime Minister and the Leader of the Opposition on a proposal for constitutional recognition. That council included the former Chief Justice of the High Court, Murray Gleeson, the Company Secretary for BHP Billiton, the CEO of the AFL, and a former Premier of New South Wales. So people from the mainstream of business and political and civic life in Australia. Under the council, its Indigenous Steering Committee devised a model for consultations that could advance the debate, and that's how we came to have a process that delivered the Uluru Statement from the Heart. As Janine said, as a long-term colleague of UNSW Professor Megan Davis, I was invited to be part of a small pro bono legal team to offer support to the process of regional dialogues that was designed. And so fortunate enough to be in the room as part of the legal support team at the preparatory stage at 11 of the 12 regional dialogues, and then at the Uluru Convention. Megan and her colleagues worked away at the intricate details and planning challenges of devising a sound, consultative and deliberative process to be conducted in a mix of urban, regional and remote parts of Australia. That meant exploratory meetings in Broome, the Torres Strait and Melbourne, and then a trial dialogue conducted with the people who would become the crucial leaders and facilitators of the process once the dialogues actually went on the road. Between December 2016 and May 2017, deliberative dialogues were held in 12 locations around Australia, with an additional meeting in the ACT. Each dialogue brought together around 100 men and women, drawn in fixed proportions from traditional owner groups, regional organisations, and significant individuals in that region. By then, some work had been done on a new idea for constitutional recognition. The intention was that it addressed the urgent need for First Nations people to have a greater say in decisions affecting their daily lives, while focusing on Australia's existing processes of parliamentary government rather than the courts. The regional dialogues were an opportunity for careful deliberation upon the merits of this voice proposal as a form of constitutional recognition. But the voice was by no means the exclusive focus of the dialogues. It was one of several options to be considered, including a statement of acknowledgement, a constitutional prohibition on racial discrimination, and treaty. So for 3 days at these dialogues, participants in each location immersed themselves in intensive discussions of constitutional civics, the situation of disempowerment confronting their communities, and the worries that people had for the future, and especially for their young people. In good faith deliberation, they worked through the differing proposals for constitutional recognition that the Prime Minister and the Leader of the Opposition via the Referendum Council had asked them to consider and respond to. At the end of each gathering, participants approved a record of meeting and selected delegates to a First Nations Constitutional Convention at Uluru. Delegates arrived at the Uluru Convention, shown in the next slide, carrying the views from their regions. And after several days of intensive discussions, they endorsed a reform agenda expressed in the Uluru Statement from the Heart. The statement called for a constitutional enshrinement of a First Nations voice and a Makarrata Commission to oversee a national process of agreement making and truth-telling. The delegates at the Uluru Convention and the dialogue participants who sent them there were determined to do something about the structural nature of their problem, the torment of our powerlessness, as the statement says. They advocated substantive constitutional change that would alter the status quo. They called for empowerment through a voice that could speak to both Parliament and government and could evolve as needs change over the decades to come. The Referendum Council recognised the power of the Uluru Statement from the Heart and the legitimacy it drew from the careful process that preceded it. The Council recommended the government and the Parliament proceed with a referendum for a representative voice in the Constitution. So, that proposal, as we know, has not had an easy path to acceptance in Canberra since May 2017. But throughout those politically challenging times, the voice continued to win wider community support amongst First Nations people and in non-Indigenous Australia. That was reflected, for example, in the countless pledges of support from individual Australians and from organisations that span all facets of economic, cultural, sporting, religious, professional and civic life in Australia. As I imagine everyone here is aware, the possibilities for a voice proposal began to change after the last federal election, just over a year ago. The Prime Minister delivered a landmark speech and issued draft proposed wording for a constitutional amendment at the Gama Festival in July 2022. That was intended to form the basis of further public discussion and consultations. He then appointed large working groups of Indigenous people to assist the government in developing the proposal and the process towards a referendum, as well as appointing a constitutional experts group. On the 30th of March, the Attorney General introduced the Constitutional Alteration Bill, effectively the bill, which Parliament had to approve by absolute majority to initiate a referendum. And that bill passed unchanged through both houses between March and June this year. That sets into train a clock ticking for a referendum to be held between 2 and 6 months after that. And it's believed to be most likely to be held in October or November this year. So to turn to the second thing I'm going to talk about, I wanted to take you through the 5 main legal features of the proposal that's currently before the Parliament to change the Constitution by enshrining an Aboriginal and Torres Strait Islander voice. So here on this slide, there are 92 words. And as I said, I'll walk through 5 key components of this proposed constitutional wording. And next slide, please, Lisa. The opening words, or chapeau, of section 129 designate the voice as the form by which this change will affect constitutional recognition of Aboriginal and Torres Strait Islander peoples as the first peoples of Australia. Next slide. Subsection 1 is straightforward and transparent. It provides for the establishment of a voice as a new constitutional entity with words that are intended to guarantee its continued existence. Next slide. Subsection 2. This expresses the core function of the voice in simple and direct language. It empowers the voice to make representations to Parliament and the government. By empowering the voice to carry out this function in a proactive way, rather than imposing obligations on the Parliament and government to respond in a particular way, it focuses on political participation aimed at influencing law and policy, not on legal duties to be enforced through the courts. The phrase matters relating to Aboriginal and Torres Strait Islander peoples can address 2 categories. First, laws and policies that are specifically on the topic of Aboriginal and Torres Strait Islander affairs. And secondly, laws and policies that apply to the general community, but will have a particular effect on First Nations people. That wording avoids artificial or arbitrary restrictions on its scope. If we can just go back to that wording, please, Lisa, for a moment. Thanks. For example, it wouldn't seem to make sense if Section 129 empowered the voice to make representations on an amendment to the Native Title Act concerned with renewable energy projects. But then, because of narrow wording, it blocked input from the voice on a general law about renewable energy projects, even though such projects are frequently located on native title land or waters. General laws and policies in health, education, criminal justice, for example, may well be the laws with biggest impact on First Nations communities. The phrase matters relating to Aboriginal and Torres Strait Islander peoples puts an outer boundary around the core function of making representations, and then leaves it to the voice to determine its priorities, taking account of the policy proposals at the time, as well as its own resource limitations, public scrutiny, and most importantly, the need to be accountable for its work back to its First Nations constituents. By making clear in this wording that the voice can address officials and ministers in the government and not just the Parliament, the provision gives Aboriginal and Torres Strait Islander peoples a meaningful say in the laws and policies that affect them. That's the purpose of Section 129. And if we omitted reference to the executive government, as some have suggested, it would impair this provision. The quality and effectiveness of these laws and policies will improve if the expertise of First Nations people, the experience of First Nations people, is capable of being brought to bear at the earliest stage, when government is identifying the existence and nature of a policy problem and beginning to canvass the range of options which might exist to deal with it. Next slide, please. Finally, subsection 3, Parliament's power to legislate the detail. So this last part of the provision confers broad legislative power to make laws relating to the voice. It means that Parliament, the elected representatives of the Australian people as a whole, is in a position to determine the details of what the voice looks like and how it will operate. Once the legislation is enacted, the voice would thereafter exercise its constitutional function in relation to any amendments or policy relating to the voice, making representations to the Parliament and government of the day. Subsection 3 is striking an appropriate legal distinction between the Constitution and legislation, and it tailors to the respective strengths of the voters and the Parliament as key constitutional actors in our system. The Australian people will be asked to determine the key question of principle, whether or not constitutional recognition of Aboriginal and Torres Strait Islander peoples should take place through establishing an enduring representative body that empowers them to have a say on the laws and policies affecting their daily lives. If the answer is yes, then the Parliament will move to legislate the details within the constitutional parameters endorsed by the voters. It would potentially mislead voters and impair the constitutional function of the referendum to present a detailed model of the voice prior to the question of principle being resolved. Voters may, for example, think they're voting on the detail of the model and not the constitutional provision, which is pitched at a much higher level of generality and principle. The perverse effect of that, indeed, could be de facto to entrench the original version as presented at the time of a referendum, making future parliaments reluctant to amend the model. And that would undermine one of the key objectives of the constitutional amendment, which is to provide flexibility for the model to evolve as it adapts to changing needs and circumstances. Constitutions are not just for now and for the next 5 years, but for the next 10, 50, and 100. So this provision follows past practice of first defining the basic outlines of an institution in the Constitution, and then determining the details later in legislation. The Australian colonies did this in referendums held between 1898 and 1900, when Section 71 of the Constitution enshrined the High Court as a key feature of the Australian system of government. The court came fully to life 2 years later, once the detail of the institution was spelt out in the Judiciary Act 1903. And then the final slide shows you again, the second last slide shows you again the overall provision. Because the fifth point I'd make to you is, if the provision for a voice is approved at a referendum, it appears as Section 129 in a new Chapter 9 of the Constitution. That makes legal sense because putting it anywhere else would sow legal confusion, for example, over the separation of powers, or place the voice in a chapter about a different set of topics. The creation of a new and distinctive constitutional body to recognise Aboriginal and Torres Strait Islander peoples as the first peoples of Australia will open a new chapter in Australian constitutionalism. To do so literally as well, through the creation of a Chapter 9, combines a sound legal choice with a location that befits the historic nature of the voice referendum. And now the final slide. This is what we anticipate the ballot paper will look like. That it will set out the proposed law as a bill to alter the Constitution to recognise the first peoples of Australia by establishing an Aboriginal and Torres Strait Islander voice. And so eventually at the end of all of this, it'll be a moment for every one of the more than 17 million enrolled voters in Australia to confront the personal responsibility we have in this matter with our constitution. We'll be asked to mark yes or no in answer to the question, do you approve this proposed alteration? Thanks very much.
Thanks, Sean, for that overview, and particularly the background, because I'm sure many of us weren't aware of how far back in time this actually started to where it's got to today. So now where it's open up to everybody to ask questions of Sean. And I guess I have one, a bit of an opening one, Sean. I understand that even before 2015, I was very fortunate at the Financial Council Australia conference in Darwin a couple of years back now. Thomas Mayer actually spoke to the audience there. And he talked about the fact that Aboriginal people had been looking for recognition in our constitution, and it goes back to King George, as in Queen Elizabeth II's father. Wrote to him, no response, wrote to Queen Elizabeth a number of times, and then it was put to a number of our prime ministers over the years. And it was only in 2017 where the Aboriginal people have said, Aboriginal and Torres Strait Island people have said, we're not going to ask prime ministers, we're not going to ask the monarchy, we're going to ask the people of Australia. And that's a key element of this, which is why I guess we're going to referendum. So I think it's totally apt that it's up to all of us to work through this and understand it and be able to share knowledge. I'm looking at the chat here and I can't see any more questions. I can't see any questions there yet. And I'm looking at hands being raised. And I'm sure I'm going to see some because we're a group of ombudsmen or ombudsman staff. And you can never really keep us quiet. So, all right. From Kate C, is this bill because Australia does not have treaty with our First Nations people, Sean?
So the topic of treaty was people's minds as they discussed, I guess, questions of structural reform during the regional dialogues, because it's a question that has occupied people's minds for a very long time when they contemplate arrangements in Australia. Of course, Australia is very unusual in the history of the British Empire for never having engaged in agreement making at the outset of colonisation. And there are precedents people have pointed to, for example, in the province of British Columbia and Canada more generally, of modern agreement making processes that seek to go back to address history, to deal with the present, and also to look to building a different future. And so that was certainly in the mix of a discussion, a very rich discussion with, you know, lots of people with robust opinions in this kind of genuinely deliberative process that was carried out 12 times over through the dialogues. And people will be aware, I imagine, that the trilogy of reforms people identified in the Uluru Statement were voice, treaty and truth. This is the first of those reforms, and it's the one that people designated, I guess, as the form of constitutional recognition they sought from the Australian people. The movement towards a treaty or a national truth-telling process under the idea of a Makarrata Commission, for example, which is generated by the Uluru Statement from the Heart, is a matter for the politics of the future. And what I think people wanted to focus on with the opportunity of constitutional recognition was something that could begin to change the dynamic in law and policy making now, because people felt a real sense of crisis and disempowerment about the way laws were made and policies were implemented by people without first-hand knowledge of what the consequences of those laws and policies were, and also without the first-hand awareness of some better alternative solutions. So they really wanted that voice to change the dynamic in the near term, I guess, in Australian law and politics, knowing that those other priorities, matters of politics and persuading a political system to come to those processes in good faith in the future. But the near-term request to the Australian people was for something that was very familiar and very recognisable as compatible with our parliamentary system of government, the opportunity to make representations to the government and the Parliament of the day.
Thanks, Sean. And from David Neeshaw from EWON, from my office, who drafted the wording of the new constitutional chapter, given that obviously a lot of work and thought has gone into that?
There has been a great deal of work, and I guess it's an evolutionary process. There's been processes, as I said, conducted since the Albanese government committed to implementing a referendum proposal in its first term of government, and it established those two Indigenous working groups and the constitutional experts group as well. But they were already working with proposals that had been through a lot of deliberation and a lot of scrutiny since 2017. In particular, Julian Leeser and Patrick Dodson were the co-chairs of a parliamentary committee that investigated the question of constitutional recognition through a voice, in particular in 2018. There were various proposals that came forward in that parliamentary proposal, and some of the submissions that were made in that proposal formed themselves built on earlier drafting proposals, including ones from Professor Anne Toomey that even preceded the regional dialogues process when the idea was still germinating. And then it's continued to be worked away, because clearly constitutional amendments have to answer to a lot of expectations and demands. They have to answer to the necessities of prevailing at a referendum, which we know is not easy in Australian politics. 8 out of 44 proposals have been successful. Requires a double majority, a majority of the national voters, and also majority in 4 out of 6 states as a minimum, as people probably know. So there are near-term necessities for a referendum proposal. It needs to be legible to the Australian people in ways that they might support it at a referendum. But it has to do its work well, as I said, in 1 year, in 5 years, in 10 years, 50, and perhaps 100. And so building in the balance of specificity and flexibility calls for a lot of judgment and nuance and debate. So I guess I can say it's a long process of evolution in the drafting of that proposal. It's been heavily deliberated upon, scrutinised, most recently by a parliamentary committee that looked at this bill, and the verdict from the parliamentary committee at the end of that long scrutiny and more than, I think, 260 public submissions and hearings in different parts of Australia was that this is a legally sound proposal that will do what people want in establishing a voice.
Thanks, Sean. You've already responded to half of one question that's come up. Can you explain what's required for the referendum to be carried, the proportion of voters in enough states, which you've explained? What happens to ACT and Northern Territory? And that's from Helen.
Yes, so the voters of people living in the self-governing territories the votes of people in the self-governing territories are counted in the national majority. But Section 128 of the Constitution, written in the 1890s, was written by people who were pretty focused on the states. And in that respect, the federalism that was at the forefront of their mind means that in terms of the double majority, the second limb of it, it's a majority of states, not a majority of jurisdictions, that determines the outcome. So it's, for the moment, 6 original states still, And that means you need a national majority to which ACT and NT voters can contribute. And then you need a majority in at least 4 out of the 6 states as well.
From a practical perspective, Hayley wants to know whether you think a tick box on the ballot sheet would leave less room for error, as in someone could be writing yes, or rather Y for yes and N for no, or something that's not legible depending on handwriting.
I should have asked my colleague who's an expert in that here at UNSW, Paul Kilday, on what the Australian Electoral Commission's approach is to annotations like a tick on a ballot paper. To be honest, I don't know the answer to that. One of the virtues, I think, of a referendum is that it's a very simple ballot paper, as that slide suggested. The instructions are not that long. One thing that's a bit long is the title of what people are being asked to vote on. It's called the long title of a bill. So every bill has as many people probably know, a short title and a long title. So this constitutional alteration that passed through Parliament has a long title, and that's expected to be what people are told is the proposal. It's the one I read out to you. But there aren't that many words on the paper, and the question is, do you approve the proposed alteration? And it says write yes or no. There's definitely no question. There'll be all kinds of reasons why that might not be in the end what people do on the ballot paper. But to be honest, I don't know. Perhaps someone else in the webinar does know and can add it to the chat. But what happens with scrutinising by the AEC of referendums when there's ticks rather than words? I know in elections, the general tendency of the AEC is try to give effect, I think according to statutory instructions, try to give effect to the intention of the voter to the extent reasonably possible. I don't know if the same principles written into the Referendum Machinery Provisions Act, which is the particular act that governs referendums. And part of the reason I suppose I don't know this answer, even though I should, and I teach public law, is how rare referendums are in Australia. So I think we have to be 64 to be a voter who last participated in a successful referendum, and we certainly have to be in our 40s or more older to have participated in the last referendum in Australia.
I'm not going to ask for people to put their hands up for either of those. I do know, though, in the Sydney Morning Herald very recently, there was a report that someone had sent an emoji, a smiley emoji, in response to a contract that was sent to them, and that was taken by a court of law as being that the contract was agreed to. So interesting. From Maxine, I'm curious about what would happen in the instance that the government disagrees with the advice of the Voice to Parliament.
Yeah, it's a good question, and it gets to the real heart of what this is. It's an attempt to change the political dynamic. It's very clearly not an attempt to engage the courts. What that means is that there is an element of the unknown, and therefore indeed risk, about this proposal from the point of view of the proponents, who wish that it brings more influence for Aboriginal and Torres Strait Islander people upon the lawmaking process and upon policy making. It's an attempt to shift the political dynamic by introducing a new constitutional actor to the debate over laws and policies that affect our First Nations people. As we know, the people who in this country suffer the most extreme forms of socioeconomic disadvantage. This is a key reason why the proposal for a voice is being put forward as a constitutional change and not in legislation. Because a constitution requires 17 million plus voters to go and cast their vote. And if they vote yes, this is a constitutional body which has received the endorsement of the people. And so when the Parliament encounters what it encounters often in our political system, which is representations about what it should do about law and policy making, In this instance, it's receiving representations not only from First Nations people, where the urgency of better policies and better laws is patent, but from a body that is constitutionally entrenched, that is a constitutional actor, and has the legitimacy that comes from popular endorsement. That's part of the logic of optimism and belief that this can be a change for the better in the way Australia does law and policy in this area. Clearly, it's an attempt to bring on board people who may, at first blush, or be uncertain about such an idea, because it's calibrated to be consistent with the existing constitutional system. It is not a radical transformation of the way law and policy making happens. It's an attempt to change the political dynamic, though, in a quite profound way through constitutional recognition in a particular area of law and policy making in Indigenous affairs. So there's a political price to pay for disregarding the considered opinion of a body that is a constitutional actor that's been endorsed as an appropriate participant in law and policy debates by the Australian people. But in the end, it is calibrated such that the Parliament is in a position, if it so decides, to disregard that advice. But it will be politically accountable for that. And presumably, if the advice is there in the public, well reported in the media, then they will have to account for their departure from that advice as well.
So from Kate, from all of your personal experience with the process, what have you found to be the most compelling reasons or arguments for Australia to adopt a voice to Parliament?
The urgency of the need to do better. We're more than 230 years beyond initial colonisation. The statistics are very clear. Government laws and government policies are not working well to address startling and deeply disturbing gaps in our community between the kind of life that can be expected by First Nations people, especially young people, and the rest of the Australian community. The sense of desperation about that crisis came through in every regional dialogue. The good faith willingness to engage in the regional dialogues was in response to an invitation from the Leader of the Opposition and the Prime Minister to respond to nominated possibilities for constitutional recognition. The people who participated in that process made unambiguously clear they supported a constitutionally enshrined voice. So they were asked the question, they provided that answer. When that proposal has gone out into the Australian community over the last 5.5, nearly now 6 years, it's won recognition and support from an incredibly wide range of sectors, organisations and individuals. And I think it's because they see the urgency, they see the legitimacy of the process that stands behind it. They see the possibility that by working with our existing parliamentary system of government, it can make a better future. And so that's not a short answer, but it's my best attempt to say why I think this deserves support.
And as someone's raised, it's a saying within the disability sector too, nothing about us without us. So there's been a lot of decision making without actually, involving Aboriginal people, which understands why, underpins why it hasn't worked. Often we hear people saying that not every Aboriginal person or Torres Strait Islander person supports the voice. And not every person in Australia barracks for North Melbourne like I do. I mean, we all have diverse thinking, don't we? What's your response when you hear that said?
Well, I think one immediate response I have is to echo your point, Janine. It's unrealistic to expect any society, any community to have a unanimous view. There's going to be diversity of view. And I think part of the really remarkable achievement of this deliberative process was the way its careful design delivered up a consensus at a national level eventually, after conducting 3-day events in 12 different parts of the country, in rooms full of people and rooms full of emotion and robust opinion. So I think it needs to be recognised that the outcome in 2017 of the Uluru Statement, from which the constitutional voice proposal emanates, is not the product of instant unanimity. It's the measured, deliberative conclusion of a process of trying to arrive at a kind of viable way of using constitutional recognition to make a better future. So the reality is, of course, there are people who disagree with this idea. They may disagree with it for a range of reasons. And some of those reasons we hear in the public arena, and it might be to do with what priority with which issues are pursued. It might be that they don't believe the voice will be effective enough. They're pessimistic about its prospects of changing anything. It might be that they have suspicions about the Constitution itself and constitutional recognition. I think what was valuable about that deliberative process was it offered 3 days on each occasion for people to ventilate those reservations, to ventilate those concerns, to hear what their peers said, what the other people coming from different directions in their own regions said about that, and eventually to settle somewhere on a consensus, because this is politics and it's about achieving something viable in the here and now. And so just as there were people with skepticism before the process started, skepticism during the process and afterwards, and that can be expressed in the public arena, and people have every right, they're entitled to have their opinion about the proposal. Just as those things are realities, the political reality is that there was a national consensus at the end of this process, an endorsement of the Uluru Statement. And that statement was taken by that body I talked to you about, the Referendum Council, not a gullible body, full of corporate heavyweights, a former Chief Justice of the High Court, and they said, this is it. This is what the government needs to go with as a proposal for constitutional recognition, because this is the only proposal we know of that has this consensus support amongst First Nations communities, as evidenced by this deliberative process. So there will continue to be people who disagree with it, but the most recent polling that's been published in 2023 by Ipsos and then by YouGov earlier this year, both had figures at 80% and 83%. When they polled First Nations communities within their sample, the subset results they found was support running at that super majority level, far above what we require for a referendum of 80 and 83%.
We've probably got one final question and one comment. I'll ask you the question first. If the voice is implemented in the Constitution, who appoints the board for the voice?
So this is a really important question, and membership is a really important question for everyone who cares about the voice, most particularly the people who've been advocating it. In the end, it'll be legislation that sets out in Australian law what the structure and membership of this body looks like. The government has committed to a process, if there's a successful referendum vote, a yes vote, to further consultation around Australia, to build on the work that's already been done on voice design, in the previous government, Ken Wyatt as the responsible minister, but away from the Uluru process and the process of constitutional recognition, because that was a government policy at the time. Asked Tom Karma and Marcia Langton to conduct an exercise in thinking through possibilities for the design of a body which would include membership and accountability and structure and so on. So there are also ideas embedded in there. Australia's had a history of representative bodies in the past that weren't established in the Constitution, including ATSIC, which was abolished in 2005, at a time when a three-person body had reviewed that organisation and come up with a range of ideas of how ATSIC could be a body that was more responsive to remote and regional opinion. And the government's made clear that it's also interested in the outcomes of those review report about ATSIC and past experience with a rep body that existed for 15 years. So I think the answer is there's a fair way to travel yet in answering that question. The government's committed to a consultation process, and there's a lot of work already in the bank being done on it to draw upon. And there's also principles of design that the government has announced in conjunction with the referendum. So it's made clear certain things that include that they must be selected by the local people of that region. And so it will be a regional body that ensures every state and territory has representatives on it, as well as Torres Strait Islanders from, I believe, the mainland and the islands. And that issues of composition will prioritise the idea that membership will be selected by the local people. So this is not a hand-picked ministerial outfit, for example.
And the final comment that I think we'll finish on from the audience is from Catherine. There's been so much hurt and damage over so long that I imagine some may not think it will change anything. So I think this is an opportunity for Australians to say this matters to us all. Certainly agree with that. I'd like everyone to join in thanking me. And first I'm going to thank Kate Temby, who most of you don't know, but Kate's on the board of E1. She's one of our community directors and she's Sean's partner. And in a conversation that she had with me, she offered that Sean might come and talk to the E1 team. And I said, I pushed the friendship and I said, well, would you ask him whether he'd talk to ANZOA, because I knew there would be an audience like this that would be interested. So thanks, Kate. And of course, thanks, Sean. I know there's lots of thank yous that have gone up on the chat as well. Really appreciate your really in-depth insights about the journey that's taken us to today. And no doubt we've got some more of that journey to undertake over the next few months. But thank you. Lots more thanks going up on the chat column. So yeah.
Thanks very much, Janine, for the kind words, and I'm very grateful for the opportunity. I really appreciate everyone's engagement, and I think, you know, this is the active conscience of 17 million of us, and every conversation that takes place between now and then can count. And so I really encourage people to talk to friends, neighbours, colleagues, and family. Because in the end, it's going to be a responsibility for all of us what our Constitution says after the vote.
So true. Thanks, Sean. Bye all.
Thank you. Bye.